fourth and final video in this particular workshop series, and where we left off last time was talking about documenting your process, all of that middle stuff that happens after the beginning stuff and before the end stuff. And so you had an assignment, and that was to participate in a role play where Bonnie and Parker were in the explore phase, and you were really listening to be able to see if you could identify and hunch at underlying interests and take important pieces of information and put them into a summary for Bonnie and Parker to document where they were. So in the meantime, what I've been doing is meeting with Fred and Wilma Flintstone. And so I would like to share with you a sample summary from their last meeting. You'll notice from the date, though, they met a really long time ago. It says October 24th, 2018. And so they have definitely received this summary already. And so here we go. So I hope you can see this. I'm going to be turning my head because this is on a different monitor for me. Oh, actually, I think I can turn it over like this. Oh, no, now I bet you can't see it anymore, right, Demi? Let me just put that back up there. All right, I'm going to assume you can see this. And if you can't, Demi would intervene and she would shut me down. All right, here we go. Oh, I've got a thumbs up, so excellent. So here's Fred and Wilma's mediation meeting summary. I'm not going to read it line by line, but I just want to point out a few things for you. And you'll note that this document is also uploaded on your Slack channel to go along with this video. So you'll be able to look at it. A few things that I just want to point out to you is just the simplicity at the beginning. So it's not anything fancy. It's called a mediation meeting. Fred and Wilma, you might include their last names. One thing that I've noticed sometimes is people who are working with a married couple that have the same last name, you could kind of fall into a bit of, I think, a mistake where you might say Fred and Wilma Flintstone instead of saying Fred Flintstone and Wilma Flintstone. It's just a really small little thing, but when people are separating, they're really trying to establish their own separate identity. So even if they're going to continue to share the same last name, they're no longer a cohesive unit. So where we would normally refer to Fred and Wilma as Fred and Wilma Flintstone, when they are separating, then it would be important to use their full names when referencing them, as Fred Flintstone and Wilma Flintstone. The other thing that I've seen, and I don't really know where this comes from, but some documents will refer to the parties as husband and wife throughout, so might identify them at the beginning of the document and then the rest of the time say husband or wife. Well, first of all, I think that's confusing because why not just use people's names? Secondly, it may not be representative of their gender identification. And thirdly, and probably most importantly, is that same as my earlier comment, they're no longer a cohesive unit. So to be talking about them in a way that keeps them identifying with whatever their roles were within that marriage, when they're really trying to move into different role identification, it's best to just use their names. So that's just a little bonus comment on that. And this is the statement that I was referring to on the previous video, that this little caveat here. So this confidential summary is prepared for the purposes of mediation and is without prejudice and shall not be used as evidence in any formal proceedings. You might even, underline the word shall if you'd like. If you want to add an explanation of what without prejudice means. Now, my assumption is that you've talked to the parties during intake as well as at the time of reviewing the agreement to mediate together, where they're both nodding their heads and signing and demonstrating their commitment, that you're explaining what without prejudice means. As a refresher, without prejudice means that anything that's being canvassed as a possibility is not something anyone is tied to and can't be used against them if the mediation process was to break down. So if I was agreeable to a $200,000 payout today and things broke down and I now want to change my position and say I'm not going to take a penny less than $400,000, you wouldn't be able to refer back to today to say, well, on July the 15th, she said she could take $200,000 and that I would somehow be limited by that. So without prejudice means I can make offers, we can discuss possibilities, not tied to it until it becomes crystallized as a final agreement. And so you'll see that my preference is to put this disclaimer at the beginning of my document. Some people will put it at the footer, some people will put it in both places. You might bold it, you might highlight it. It's a very important piece of your summary. And so this is just an example. It's not a format that you need to follow, but it'll give you an idea of some ways you can set up your own summary. And I hope that you actually did try the assignment before seeing this video, because it gives you an opportunity to feel like, oh, hey, this is what you created and worked for you. Now there may be some things in my sample that you also want to adopt, but rather than just say, oh, well, this is the way I'm going to do it. Not that there's anything wrong with that, but we always like you to be able to have your own personality and style shine through in your documents and everything that you're doing. So I repeat what the draft agenda was agreed to as the first thing, have this little update on the fact that they sold the car and where the money is. They've decided not to sell the couch, which was obviously an issue that they were discussing. We had a discussion here about their joint accounts. You can see here that in red, I've identified a homework item. Wilma has requested the bank provide her with statements from February 2009 to December 2010. We had a discussion about investments and pensions as number 4 here on the list of things. And you can see I've bolded and I've also chose to underline the word agree, that they've agreed to keep these separate. And so as you go along throughout the summary, you can see the agreements are bolded and underlined, homework items are in red, and the very last part here of the summary is next steps, talks about when the next meeting is going to be. There's a house appraisal, so that they're waiting to have that be completed. And then I have prepared a draft agreement for Fred and Wilma that we will be adding the final details to, and then we're anticipating one more meeting to review the agreement together. A few things to point out, and as far as the formatting, I'm trying to include some white space to make it a little easier for people to read, so it's not just so dense and heavy. I'm using bullet points here. It's not full sentences. These would have been notes that would have been compiled from my own just handwritten notes during the meeting, as well as what was on the flip chart. So there you go. That gives you a bit of an idea of what is a summary of a meeting could look like, and interested in what your meeting summary looked like. So now let's carry on, and I'm going to just pull up the PowerPoint that we've been working off of. And we are now, this was the slide that we left off last time, we're at the end, documenting an agreement. And we have a few things to talk about in this segment. So a little bit about what settlement documents, are all considered to be, and some of the terminology that goes along with that. What actually should go in, what's the content of the format of a settlement document. If we're going to be bridging for independent legal advice, what would our cover letter look like? And then what are some of ethical considerations and really the clarity of our role as a mediator when we are documenting agreements as we go along. So first of all, there's nothing special about a document that documents an agreement. So every time you do a summary that records little baby step interim agreements as people go along, that's a documented agreement. So there will be a series of agreements, even if the agreement is simply when they're going to meet again, or the agreement might be that they've decided to not continue with mediation. So every time something has been decided, that's an agreement and you're documenting it. the question really becomes around enforceability and what level of formality is needed from the perspective of a third party for that agreement to be enforced. What level of formality is needed for the parties to rely on that written document should one of them change their mind at a later date? These are the relevant considerations. So you will have heard some terms, including the term that's included in the regulations that say you need to have 7 hours of training in this area, and that is a memorandum of understanding. So what is a memorandum of understanding as compared to an interspousal agreement or just some other agreement? Let's break that down, shall we? So any type of decision that's made that is just reached orally is still an agreement, and it's still a contract. It's a verbal contract. So Demi and I might reach into an agreement that she's going to buy my van from me for $3,000. We've talked about it over lunch. That's our agreement. There may not be even any witnesses, or we might have been out for lunch with other people that heard us reach this agreement, but there's no witness requirement. We haven't written it down anywhere. This was just an agreement that we've reached between us. Now tomorrow, if I've changed my mind and I no longer want to sell her the van for $3,000, but I think I'm going to just try to eke up the price a bit, and I say, well, Demi, I've changed my mind. I want $5,000 for the van after all. Well, the fact that we didn't have anything written down could make it very difficult for her to enforce that agreement. So she could arguably take me to the court, to small claims court, and say, hey, my mom and I, we had this agreement about the van, and she's trying to change the terms of it now, and the judge would take a look at the circumstances and listen to our evidence. But if I feigned, poor memory, and I'm like, well, I don't know for sure that we agreed to $3,000. And in fact, I'm pretty sure we were just like, we were going to sleep on it. And when I woke up the next morning, I decided it should be $5,000 instead. It would be difficult to enforce that kind of an agreement because we didn't have anything documented. But don't forget that an oral agreement is still considered a contract in contract law. There are some things that keep contracts from being considered valid. So for example, if one of us doesn't have our mental capacity to enter into an agreement, maybe because we're intoxicated or we have dementia, and in the moment of reaching that agreement, we don't know what it is that we're doing, that is not an enforceable agreement, whether it's written down or otherwise. So there are other things like there has to be a meeting of the minds is the phrase we use in law to say, well, were we talking about the same thing? If I thought we were talking about my van and Demi actually thought we were talking about a Ford 150 truck, because everybody has to have a Ford 150 truck in Saskatchewan, then we did not have a meeting of the minds. It might be hard to imagine how we could have miscommunicated at that level, but that could be the case. So that's where an agreement would not be able to be enforced and wouldn't be considered a valid agreement. And there are some other types of considerations like whether there was undue influence or not. So this is all a little bit outside of the realm of what we're talking about in this video specific to mediation, but it's just important to orient you to know that there's no particular magic to what type of a written document documents an agreement, or even kind of saying, well, that's not an agreement until it's written down, because in fact it can be. The issue is all about having the clarity and the ability to enforce that agreement. So we know an oral agreement, a verbal agreement, that is still a contract. When we are documenting little baby step interim agreements along the way through a mediation process, those are agreements as well. But if somebody doesn't follow through on that agreement from mediation meeting to mediation meeting, then it's going to impact the trust that's really important in the process. So let's take this example. Let's say they agreed that the child was going to be picked up at 12 noon on Saturday, and the one parent arrives at the other parent's house, and that parent says, no, I've changed my mind. I'm not letting you take the child at 12 noon. Sorry, we'll have to just talk about this in mediation. So certainly we're going to come to mediation, and that's going to be one of the topics to talk about. And there isn't going to be any kind of like actionable matter that the parent who didn't get to pick up the child then goes to court and says, I'm looking for some sort of remedy for the fact that I didn't get to pick up the child. We had an agreement, and even though we know that the summary couldn't be submitted, but it submits evidence to say we had this agreement. Well, that's not really practically going to happen, but in the mediation meeting, what's going to happen is it's going to be very difficult then for that parent to have any trust in anything further that the other parent might purport to agree to. So it may not be enforceable in the sense that there's some sort of written formalized agreement that a parent could take to a third party decision maker and say, this has been breached, but there's still a consequence. And that is why it's really important for people to be thinking about their agreements from meeting to meeting, those interim baby step agreements, what it is that they're agreeing to, and are they actually going to be able to follow through on that? Because if they don't follow through on it, there will be a consequence to the integrity of the process and their ability to move forward. Okay, so we've talked about verbal or oral agreements. We've talked about those interim baby step agreements that are just kind of help you get from one meeting to the next meeting. What about when there's an agreement reached? So they've worked through their whole process, or maybe they've worked through the process to a point where there's something like, let's say they've agreed that they're going to sell the family home and they're going to divide those proceeds equally. There isn't any other property that they're going to be dealing with. So even though they have a whole lot of other things to still sort out, they've reached this final agreement with respect to the family home. And so will that be documented somewhere that they can rely on it and it would be enforceable? So this is where your memorandum of understanding could come into play. So in addition to a summary, you might have something just a little bit more formal that you put at the top of it, memorandum of understanding, that then says parent one, their name. We'll just continue to use Fred and Wilma as an example. So Fred Flintstone and Wilma Flintstone on this day of this year have agreed to the following, this, this, and this, and they might sign that memorandum of understanding, or you might put a big disclaimer at the bottom of that memorandum of understanding that just says, this is simply documenting the understanding between the parties as to their agreement, and it would need to be put into some other type of format with independent legal advice in order for it to be considered legally binding. This is a caveat or a disclaimer that you'll often see on documented agreements coming out of mediation. There's a couple of reasons for that. So one reason is simply the comfort level of the mediator. So the mediator might feel like, I'm okay with documenting what you've agreed to basically, but I don't really have the confidence of being able to put this into some sort of real formal document that I know that you're going to go and take to the bank or you're going to rely on in some way. I want to help you to get there, but I'm going to do it by just providing this, really in essence what it is a summary, but I'm calling it a memorandum of understanding. I don't want my signature on it. You guys don't put your signatures on it. You just go and you take it to somebody who's going to draft it up in a way that it, will meet some sort of formal requirements. And so as a mediator, if that's your level of comfort on your drafting, that is totally fine. Another reason why you might not actually sign or have the parties sign this memorandum of understanding is that that might actually be outside of what you're allowed to do pursuant to your code of ethics of whatever organization you belong to. So that's something that you want to look at very carefully. So if you're a member of Family Mediation Canada, for example, there is a clause in their code of ethics that speaks specifically to this issue. So whoever, whatever membership you're with, always just double check to see what parameters that you must adhere to. There are some schools of thought that it would be inappropriate for a mediator to witness the signature of a mediation client, because if that agreement was to break down and then the parties wanted to call you, or one of the parties wanted to call you as a witness to that agreement, that falls outside of the parameters of what we do as mediators. And in fact, in our retainer agreement, in our agreement to mediate, you'll recall, says the mediator shall not be subpoenaed or called to give evidence of any sort. Now, the question that I always have, though, is what is it that you would be called to give evidence about? When you are witnessing a document, what are you doing when you are witnessing a document? Are you somehow signing off with authority as to the contents of that document and giving your blessing to the contents of that document? Or are you actually just attesting that that person's signature was made by that person because you were there and you saw them actually sign, and so you're witnessing their signature? If I was called to be a witness to somebody, to say, hey, is this your signature? And I'd say, yes, this is my signature. And they say, well, when you signed this, was this were you witnessing the signature of this person? And then I'd say, yes, I was. And then if they wanted to ask me more questions about the agreement, I would say, I can't speak to that. So my comfort level in terms of witnessing somebody's signature is based on my understanding of what I could possibly be called to attest to. I'm simply, I'm giving evidence as to the fact that, yes, I was the witness to that signature, and I knew the person who made that signature to be the person that signature purported it to be. So from my perspective, I see that as low risk. But keep in mind, too, that I'm approaching this as a lawyer as well. So my comfort level in witnessing documents, whatever those might be, could be much greater than yours. And so first and foremost, check in with yourself, do some reflections as to how you feel about witnessing documents. Then also check your code of conduct or ethical requirements, depending on what organization you're a member of, and see whether it falls outside the parameters of what you're allowed to do. And then ultimately, if you do witness documents, then you need to think about what are you communicating to the clients as to your role of witnessing, so that it's very clear. And you could maybe even have that written down on that memorandum of understanding that the mediator witnessed these signatures simply as evidence of that being the person who matches up with the name of that signature. So I don't want to make this unnecessarily complicated for you, but I think it's a really important discussion to have, because there's lots of conversation in the mediation community, in the professional community, about whether or not it's appropriate to witness a document, or even to have parties sign a memorandum of understanding. And what is a memorandum of understanding? It's basically like a summary of what they've agreed to, and whether it's a full, final, global summary of everything that they've agreed to, or just one particular piece that is being finalized, like the sale of the home, then all that speaks to is what the content of the document is and how long the document might be, because it depends on how many issues have been agreed to. So we have the oral or verbal agreement, and we understand that that's still a contract. It's difficult to enforce because there isn't an evidence as to what it was that was agreed to. You can have a written agreement that's just between the parties, that is drafted between the parties, that has a witness of a neighbor or has no witness whatsoever. It's just something that the parties have put together. Now, if that agreement was to break down, there would be written evidence to say, well, this is what we've agreed to, but some of the questions that could come out of that is, whether you understood what the contents of that agreement were, and you thought that that read Ford 150 truck when in fact it actually read van. And so you should probably, just double check and make sure that one or both of you aren't, misreading documents, but you're having the common understanding of what's there. If the parties are in mediation though, and you have prepared the summary, and whether you have put at the top of it memorandum of understanding or what you've labeled it to document their agreement, they may have signed it, they may have had you witness that signature, their signature, and it may or may not be sufficient for a third party. So it may be sufficient for the purposes of documenting what their agreement was, because it's been created with your assistance and not just on their own. Sometimes our assistance doesn't actually help them, because maybe we have fallen into the trap of using too complicated of language and they do a better job on their own, but that's a different topic. So it's then they take this piece of paper and maybe they give that piece of paper to the realtor, for example, to say, hey, we've agreed that we're going to sell the house, or that they give that piece of paper to another lawyer that's the real estate lawyer, the person who's not involved in their settlement discussions in any way, but is instead the person who's going to be taking in the sale proceeds, and then is going to rely on that document to share the proceeds equally. Will that have the level of formality that the realtor and the real estate lawyer are comfortable with? Chances are probably yes, but maybe not. Maybe they'll say, well, we're only going to be comfortable in honoring this agreement if you also have a certificate that shows you've had independent legal advice. So they can write their own agreement, they can have the mediator draft up a memorandum of understanding. That is evidence of what they've agreed to. Whether a third party will then be comfortable relying on that level of formality or not, well, you have to ask the question, right? And just because somebody in one instance says, well, it's not enough for me, doesn't mean that somebody else who has that similar job or profession would take that same position. So don't just know that every time this comes up, just to have the parties ask, or for them to give you consent to go to the professional and ask to say, hey, if their agreement is documented in this fashion, is that sufficient? Don't forget that there are tons of people out there that are figuring out how to separate their stuff and entering into parenting and support arrangements just between them. They're not utilizing supports of anybody. They're not using a mediator. They're not using lawyers. They just want to figure it out themselves. How do you think they're documenting their agreements? What level of formality are they using? So I just bring this to your attention so you don't get too hung up on that piece. Just know that in some circumstances, a greater level of formality may be needed than in others. Now, there's another document that you will have heard referred to before, and it will come up lots in your work as a family mediator, and that is what's referred to as an interspousal agreement. The term of art, interspousal agreement, is found within the Family Property Act, and it has a defined description of what is an interspousal agreement. And you can go and check, and I encourage you to do so that you're very familiar with what the Family Property Act says about interspousal agreements. But here's kind of the gist of it, is that it is an agreement where each party has had independent legal advice. And when each party has signed that agreement, it doesn't mean that the witness has to be the lawyer, but the lawyer has to have at some point had a conversation privately with their client, separate and apart from the other individual involved, to explain their property rights under the family property legislation and make sure that they understand the contents of that agreement. And the lawyer will sign a certificate that attests to having given that separate and apart advice, and that they've never represented the other parent or other party in matters related to the separation. So that is a specified definition that exists in the Family Property Act, and only in the Family Property Act. Our other pieces of legislation that are relevant in family law, they will refer to agreements, but will refer to agreements not in that same formalized sense that an interspousal agreement is. Now, why does the Family Property Act have a special reference to a special kind of document? Probably because property and the amount of value that can be at stake, it's sometimes that they're really looking for a way to transfer the risks from the parties to the lawyers. So let's just continue with our example of Demi and I and our vehicle purchase and sale. And so if I've had independent legal advice in our agreement, our interspousal agreement, and afterwards I want to ask for more money because I've discovered that my van is actually worth way more than $3,000, then I might, try to go to the court and say, hey, there was a problem with this agreement. I didn't have all the information. The court sees that it's an interspousal agreement and that I had independent legal advice and says, well, I'm really sorry. I don't know if they'd say I'm sorry, but basically they were going to send me back to the lawyer that provided me with the independent legal advice. Because if there was something wrong with the advice that the lawyer gave me, or perhaps the lawyer was, acting outside of their realm of competency, or they didn't check to ensure that I had capacity and I signed that agreement without capacity, or whatever it might be, the responsibility falls to the lawyer. So if the lawyer made a mistake, the lawyer has insurance to deal with that. So then rather than Demi having to defend a claim or to take a position to say, no, this agreement is valid, or bear the consequence of my changing my mind, that consequence is transferred to the lawyer and their insurance if indeed the lawyer made a mistake. So now think about this then, because we often have mediation clients who say, no, I really don't want to use a lawyer. But sometimes we also have where one person wants to use a lawyer and the other person doesn't. And so if you think about who is actually protected in getting the independent legal advice, certainly the person who's receiving the independent legal advice is getting value for that. There's no question. And it's really important to have independent legal advice so you do understand your rights and obligations. But quite frankly, it's the other person who gets protected. And so if I say, no, I don't want to have independent legal advice, and then later I don't like the agreement, when I go to a third-party decision maker to complain about that agreement, the third-party decision maker actually has to look at the agreement through the lens of contract law and say, okay, well, did you have capacity? Was there a meeting of the minds? Were the material terms and conditions clear? Was there any undue influence? And so continuing with the Demi and Charmaine example, Demi then has to prove, the burden will fall on me as far as the onus of burden of proof, but she'll be engaged in that process. Whereas if I had had independent legal advice, she's less likely to have to be engaged. There's never any guarantees. We know it depends, but less likely to, because I'm going to be sent back to my lawyer to take it up with my lawyer. So when you are working with families where one person's saying, no, I don't really want independent legal advice, not only do you want to encourage them to consider independent legal advice, but you also do want to bring to the attention, and you want to have this conversation with both parties in the room, but to say independent legal advice really protects the longevity of this agreement. And what's the point in entering and going through a mediation process to just get an agreement that you can't rely on? And so if one of you doesn't get independent legal advice and the other does, well, then the person who hasn't gotten the independent legal advice, it's causing a problem for the other person. And so then you can have a discussion around what the options are. We've certainly had clients that have sometimes agreed to pay for the independent legal advice for the other person, just to have that extra level of protection for the agreement. So the interspousal agreement has that specialized definition under the Family Property Act. A lot of times people will just use the term interspousal agreement in all sorts of agreements that occur between spouses, right? Because interspousal agreement means an agreement as between spouses. When you're using a capital I and capital A as an interspousal agreement or interspousal contract pursuant to the definition of the Family Property Act, then it has to have all of the components as laid out in that legislation. All right, so that was a lot to digest. And so let me just see if I can summarize it really easily for you, because what we're doing here is we're talking about the kinds of documents and the terminology. So think of it like a spectrum. On the lowest end, or the simplest end, is that every single time a decision is reached and agreed to, that is an agreement. And you will document that throughout the mediation process through your summaries. Those kinds of agreements do not give rise necessarily to some sort of legal consequence or remedy if there's a breach, if somebody doesn't follow through on it, but it does have a consequence and an impact on the mediation process. When parties have reached agreements that they want to document, they can document those between them. If they're documenting between them, there's no guarantees that they're actually both understanding what it is that they are agreeing to in writing, but at least it gives them some sort of evidence, something that they can point to say, well, this is what we've agreed to. If you are preparing an agreement for the parties, you might call that a memorandum of understanding. You might have the parties sign it, you might actually even be a witness, but it will depend on your comfort level in engaging with that document in that way. It will also depend upon what your code of conduct or code of ethics require you to abstain from doing, depending on the organization that you are a member of. Know that that memorandum of understanding has some formality to it, in that it says memorandum of understanding is no longer without prejudice. It's an evidence of what their agreement was. If you don't want to be called as a witness to attest to that signature being the signature of the person that it's purporting to be, then maybe you have a clause in there that says that, you know, you're not, or maybe you just do not participate in the witnessing of it. You might actually have as your parameters that a memorandum of understanding looks a little different than a regular summary, but you put a disclaimer on the bottom that says this is not a legally binding enforceable agreement until the parties have had independent legal advice. Once again, this depends on what your comfort level is there. Keeping in mind that if we make things too complicated for folks, that it can create some barriers. And so be very reflective about where your particular concerns and fears and needs may be, and then unpack those to design your own process that you think will best support the families that you're working with. Then on the far end of the spectrum, in terms of the most formalized kind of agreement, is an interspousal agreement that is typically prepared by a lawyer, but that doesn't have to be. The significant, criteria for it to be elevated from just a summary or a memorandum of understanding is that it has independent legal advice. That independent legal advice is for both parties, and it's in order to transfer the risk of there being a future problem with this agreement, as far as a difference of opinion as to what it means or what they had actually agreed to. It's transferring that risk back to the lawyers that gave that independent legal advice. All right, there's no quiz on this, but you may want to quiz yourself to see if you have a clear understanding as to what the different kinds of settlement documents could be, the names, the titles, the words you're going to hear floating around. The contents and format of a settlement document. Well, what should be in a settlement document, and what does it look like? Well, I want to share with you what Fred and Wilma's document looks like here. So bear with me here for a moment, and I'll just pull up their draft agreement. And I'm sharing this with you because I think that there's some real curiosity around what a formal agreement might look like, even if this may not be the format that you end up following. So the things that I will point out to you here is right off the bat, you'll see it's called separation agreement. So in Fred and Wilma's case, they were not having independent legal advice, and so it wouldn't be correct for me to call this a interspousal agreement, because it's not going to meet the definition under the Family Property Act. And in fact, it may not even deal with property. In their case, it does. But some situations, people are entering into simply parenting agreements agreements or support agreements, and it's not under the Family Property Act. It's still an agreement between spouses, so it's still an interspousal agreement in the sense it's between spouses, but it's not an interspousal agreement in the definition of the Family Property Act. So we have the parties. They're typically identified, so maybe by where they live. You might replace having to say their full name throughout the document by just referring to them by first name. And then this beginning part is what's called the preamble. And this preamble further sets out some details. So we know it's this particular Fred Flintstone and Wilma Flintstone, and not a different Fred Flintstone and Wilma Flintstone that were married on a different day in a different location and have different children with different names born on different days. So we're putting all of those kinds of identifying features into the preamble. And this is also a place where you could really capture the essence perhaps of the agreement. So you could have some commentary in there around, well, they've engaged in mediation services because they want to prioritize their children. They want to be amicable and respectful. So it's just a way of kind of maybe table dressing or setting the stage to say this is what the parties are intending. And so therefore, here's their agreement. So they've agreed to a date of separation. They've agreed to some things around decision making for the children. They've reached some agreements about parenting time with the children. They've reached some agreements about how they're going to spend holidays and school calendar breaks, etc. There's a section here that talks about their incomes. You'll see that a notation that they've exchanged the necessary financial information, and there's some information about what the income for each parent is set at and what their jobs are. And there's nothing in any of this that is particularly crucial in order for this to be representative of an agreement between them. They could reduce all of these clauses to a couple of sentences that say, well, this is how we want to parent, this is how we want to do support. But the more details that might be part of the separation agreement, whether you call it a separation agreement or a memorandum of understanding, or if it ultimately becomes an interspousal agreement with independent legal advice, in order to meet that definition of the Family Property Act, the more details that sort of explain how they reached the agreement that they reached helps for clarity, and also for when they have to go back to the agreement because they've forgotten, why are we doing it this way? Or maybe something has changed and they need to go back and do a review. So if you have some references as to where this information came from and how they reached their agreement, what was important to them about it, that just helps for that clarity going forward. So you'll see there's a section here on child support, a section here on spousal support, and here's something that might look unexpected, and there's like a highlighted section. What is that all about? So I am utilizing my draft agreement as a way of some further communication with my client, and I'm preparing the clients for their independent legal advice. And I have made a little notation here to Fred to say, well, Fred, look, at your lawyer might ask that you confirm you have life insurance. And so this would have been something we probably talked about in a meeting. And I'm just wanting to flag this for Fred and Wilma as they go forward with their next step. So if you are helping in the drafting of a formal looking kind of a document, you can still use this as a mode of communication between your clients, as well as with the lawyers that are providing independent legal advice. And I'll also show you a sample transition letter, and we want to talk a little further about that momentarily. And you see here, there's also a section to deal with their family property. There's a Canada Pension Plan waiver. Now, here's where we get into some sort of standard kind of more legalese clauses, like a release of rights in one another's estate, a general release, a comment that this, the agreement would survive a future divorce. And, Fred and Wilma decided they wanted to get a divorce because maybe they've just decided to separate and they're going to live under the terms of their separation agreement. But then then when Wilma decides that she wants to get married in the future and she realizes she hasn't gotten divorced yet, maybe it would have been a good idea for them to get divorced at the same time. But everybody has different reasons and things that are important to them about whether they complete that final step or not. There's a section here that just makes note that if there were going to be any changes to the terms of the agreement, it would have to be in the same formality. There may be other documents that need to be signed. This clause here on severance, you'll see this in many contracts, not just in agreements between parents or spouses. A severance clause is a way of holding up all the contents of the agreement, even if there was a clause that had to be removed. So if the parties did end up in court for some reason and a judge reviewed the spousal support section, just as an example, and said, well, we're going to do something different than what the parties agreed to, then the parties could rely on the severance clause to say, we want the rest of the agreement to still be enforced. Normally, you can't pick and choose what parts of a contract you're going to abide by and which ones you're just going to discount. Intention for agreement to be binding on estates. So if somebody, if there was a signature on the agreement and then that person, unexpectedly was to die before the various pieces of the agreement had been implemented or acted upon, then their estate would still need to follow through on that. And then we have this independent legal advice section. So if you are helping the parties at this stage where you're going to take their agreement and you're going to put it into a formalized kind of a format for the purposes of them taking that agreement to a lawyer for independent legal advice, keeping in mind each party has their own lawyer at that step, then this clause here about independent legal advice is what the lawyers are going to be looking for in this agreement. So you'll see that Fred and Wilma have each had independent legal advice regarding this agreement. B, they understand the nature and effect of the agreement and what their respective rights, obligations, and claims under the agreement are. They're aware of all possible present and future claims with respect to maintenance that they might have under the Family Maintenance Act for Saskatchewan, or the Divorce Act, because you'll remember Fred and Wilma are married, and that each fully intends to give up those claims. They are aware of the rights and obligations under the Family Maintenance Act for Saskatchewan. They're aware of the rights and obligations under the Family Property Act. And so the final piece here, that they're signing the agreement voluntarily and without duress, why do you think this whole section exists? It's so that if in the future Fred or Wilma decided they didn't like the agreement and they didn't want to abide by it, that the other person who wanted the agreement to remain in place would rely on this independent legal advice section to say, hold on, when you signed it, you were agreeing that you had independent legal advice. You understood what you were giving up and what you were committing to, and it was voluntary. You might not have wanted the separation, but nobody was putting undue pressure on you in such a way that would have to say that I was under duress and this was not of my own free will. And so a rose by any other name is still a rose. So if there was something going on that this is not accurate, well, that's going to be relevant evidence, but let's just assume that what is written here is the truth of the circumstance, then that is relied upon in the future if somebody's trying to get out of the agreement later. Now, this is just an example of what more formal format of an agreement might look like. My own agreements that I draft for clients, I always make sure have a dispute resolution clause in it as well that says if the parties can't, they can't agree to something that's in the agreement, or something that comes up that they weren't expecting at a later time, that they would need to return to mediation before they could bring a court application. All right, so just as if we were in live time, I'm going to take a moment here and have a drink. Okay. Hopefully that will help that tickle in my throat. All right, so now we've seen what a formal agreement could look like. a lot of lawyers have their own precedents, and so you may find that it's kind of a waste of your effort to try to take the parties' agreements and put it into this kind of formal looking agreement to have them take to lawyers, because the lawyer might look at it and go, okay, thank you, but I want to use my own precedent. So rather than you coming up with the agreement the way that you might want it to look, you might just simply give them the list of what the parties have agreed to. And you would do that by way of a transition letter. That transition letter might also have enclosed with it, I'm just going to share with you a transition letter in Fred and Wilma's situation. You might also include summaries from the previous meetings so that the lawyers can see sort of what the steps were that got them to the final agreement. But that depends on the clients. And like I've mentioned before, you need to make sure that you've got their consent to share whatever you're going to share with the lawyers. So Fred's lawyer is the great Gazoo. And I might send this letter on my letterhead, or I might just send it by way of an email. The level of formality will depend on the lawyer, quite frankly, and what my relationship is with them. If it's somebody that I do a lot of work with and I'm comfortable with a real informal exchange, it's most likely going to be in bullet point in an email. For simplicity, it's somebody I've never worked with before, it's somebody that I know that their style is a little bit more formal, and it's likely going to be by letter in a more formal looking way. So here, let's take a look at this letter. I'm explaining that I've been working with Fred and Wilma in mediation context, and you can see that Wilma is represented by Barney. So in this example, I'm sending the exact same transition letter to each lawyer so that both lawyers have that same information going into their independent legal advice with their individual clients. So I've attached some initial information regarding the income, the approved draft of the separation agreement, and the final property charge that was used. Now, you might have different things that you include. Like I said before, you might include copies of the summaries of the meetings. I've talked about what it is in the spousal support agreement that is maybe a little bit different than what the lawyers would be used to seeing, and I'm providing some rationale for that. And that I end here kind of on a note of encouragement, right? Fred and Wilma are eager to get their independent legal advice. They've approved the draft agreement and the additional property information that I might have as part of my file. You know, I'm offering to share that with them if it's needed, but I'm making a note that there really are limited aspects to the property division. And then just invite them to contact me if they have any questions. And that just is an example of bridging between mediation and independent legal advice. I'm not suggesting that you wait until the very end to have that first contact with the lawyers, but sometimes the clients themselves, either for some reason don't want to tell you who their lawyers are that are giving them advice outside of the mediation room, or haven't had lawyers, that they've waited until the end to go and get a lawyer. And they may actually say, hey, I'd like to have independent legal advice because that makes me feel more confident in the durability of this agreement, but I don't know, who should I go and see? So as a mediator and in building your business, you want to be thinking about building some relationships with family law lawyers who are willing to do independent legal advice sessions for mediation clients so that you can refer people that are looking for a lawyer to work with. And that will also help them in having their agreements honored and able to be put in place in a way that it matches up with what their expectations are without a tremendous amount of fuss, because you already know what that lawyer is looking for. And you know, I have the benefit of being able to share my perspective both as a mediator and as a lawyer. And I can tell you that when a mediator sends a client to me for independent legal advice, the things that I find really helpful is to be given a heads up by the mediator to say, hey, I've been working with this client or on this matter, and I understand that Wilma's coming to see you for her independent legal advice, and here are some of the things for background information, and that helps me to prepare for meeting with the client. I think sometimes people who aren't lawyers are uncomfortable in contacting lawyers or talking to them, whether it's in a professional capacity or even when you're getting independent legal advice for that matter. But we actually, from the perspective of how well we can do our job, the more information we have, the better. So as a mediator, don't feel nervous about having contact with the lawyers that are giving advice to the families that you're working with. Just always, always remember that you want to have the consent of the clients first. All right, let's go back to our PowerPoint here. Just bear with me here for a moment while I bring that up, and we'll get into our shared screen here. All right, so now I know our dude here in this picture looks like he's very stressed out about the documentation. So that's not you as the mediator. That's maybe the client who's like, oh, I'm really feeling stressed out about it. So you'll help them by kind of helping them through the various different steps here at the end. So let's review what we've talked about. We've talked about the different kinds of settlement documents and the terminology that comes along with that, what a settlement document could look like as far as the contents and the format, a cover letter to bridge for independent legal advice and what that could look like. And we still want to discuss some ethical considerations and the clarity of our role as a mediator and how that looks different than other professionals that are working with the family. Now, before we talk about that though, let's just return back to Bonnie and Parker. And let's think about what our agreement might look like, or what our transition letter to Bonnie and Parker's lawyers might look like, or even what just a simple summary of their agreement could look like. So here are some of the terms. Bonnie's going to stay in the family home and Parker will rent an apartment nearby. When it's time for Parker to spend time with the children, Bonnie's going to go and stay with her sister so Parker can stay with the children in the family home. And if you're interested, this is what we would call a nesting arrangement for their parenting. It sets out what days of the week each parent is going to spend time with the children, and that they've decided that they're going to actually list the family home for sale. So this is obviously a temporary measure, having Bonnie continue to stay in the family home as her primary residence. They're going to list the family home for sale, they'll split the proceeds, and until things are finalized, they're going to equally contribute to household expenses. Bonnie has retirement savings and a pension, Parker has a truck and a motorcycle, Bonnie has her business account and a checking and savings account. You can see Parker is an overdraft with his checking account, and there's a line of credit that Parker has agreed to continue to service by making those monthly payments. He's not going to pay Bonnie spousal support or child support because he's servicing this line of credit. And then there's a notation as to their respective incomes, and you can see that Parker does not want to meet with a lawyer to receive independent legal advice. Now, this might be a point in the video where you press pause just to ponder a little bit about Bonnie and Parker's situation and what they have reached as an agreement, but you can also come back to it. And here are the things that might be on your mind. So working backwards, I mean, you might, that last comment, Parker doesn't want to have independent legal advice. Do you have any concerns about that? What kind of conversation would you want to have with Bonnie and Parker together about Parker's interest in not having independent legal advice? We know from what we've talked about earlier in this video that there isn't anything magical about that independent legal advice that makes this any less of an agreement. If they don't have the independent legal advice, but it's really a question of enforceability, as well as if there's a problem in the future, where does the risk lie, and will that become problematic for this particular family? Just because their spousal relationship has ended, their ongoing relationship has not, because they have children together. So if there's going to be a problem with respect to their agreement and the implementation or ability to follow through on on it, and then they are going to re-engage in some sort of conflict, perhaps they'll just come back to mediation and be able to work through it there. But there may also still be an added layer of value to them to have that independent legal advice. So what do? Well, we know that our job as the mediator is not to tell people what to do, but instead to have some curiosity and be very genuine in our approach. So Parker says he doesn't want to have independent legal advice. You might ask Parker some questions like, tell me a little bit more about your thoughts in that regard. Is there something that you are concerned about as far as getting independent legal advice? Here are the commonly cited concerns. One is somebody is concerned that it's going to cost too much money. Well, maybe you have some information about how much it would cost. Perhaps you've developed some relationships with a handful of lawyers who have agreed that they'll provide independent legal advice to your mediation clients at a reduced cost or for a flat fee. And so you could potentially provide that information as an option for Parker to consider. Another commonly heard objection is that I don't like lawyers. And so then I'd have some more curious questions about what the basis of that is for. It might be that they've just watched some movies where the lawyers seem really mean and unfriendly, or they might have had some previously bad experiences. And so it may be needing to unpack that, making suggestions around, again, we need lawyers that you have relationships with to be able to say, well, would it be helpful for you if I, introduced you to a lawyer that I actually think has a different description, so could overcome those concerns as far as why it is that you believe you don't like lawyers. Or it could be that they're concerned that the lawyer is going to make it unnecessarily complicated. So again, what is possible? What are the options that could be evaluated that will keep it from becoming unnecessarily complicated? And so it's like a mediation within your mediation, right? To say, well, what is the issue? The issue is Parker doesn't want to have independent legal advice. What are some of his underlying interests there that he's trying to meet? What are his priorities, his expectations, his assumptions? That's a really big one here. What's he assuming about the cost and the complexity of having a lawyer involved? What are some of his concerns? What's his actual goal? And then be able to start brainstorming some options. At the end of the day, if Parker decides he doesn't want to have independent legal advice, he doesn't have to have independent legal advice. Your job as the mediator is to help him evaluate those options, one of them being not to have independent legal advice, another option to have independent legal advice, and there could be some ways in which you could support Parker getting that independent legal advice. And in evaluating those options, your job, your responsibility as the mediator is to make sure that Parker and Bonnie understand that if they don't have that independent legal advice, that it could be problematic for them as far as putting this agreement into place and having it be enforced by a third party. It may also be that there's some clarity that would be beneficial to them, but at the end of the day, their decision to make. You may feel better about your professional file if you have a notation about the conversation. Some mediators will have a bit of a checklist that then they'll have the clients sign or initial to be able to have some comfort in your file that if Parker and Bonnie at a later date were frustrated by something, that they want to then pin the blame on you for not having forced them to get independent legal advice, be able to say, well, here's the thing, is that this is what I do on all my files, is I go through the various pros and cons, and the parties have signed off on this to say that they didn't want to have independent legal advice. Like, there are different ways in which you could protect yourself if you were concerned that if you had a client that wasn't getting independent legal advice, would at a later date come back and complain about that. So in further reflections, is there anything about Bonnie and Parker's agreement that you might want to flag for the parties? Anybody who's watching this video who has taken the financial support intensive module, you know that the child support piece is probably something you need to flag, because child support is the right of the child and not for the parents to negotiate away. That doesn't mean to say the parties can't enter into this agreement, but it's important to flag it for for them to say that if you choose not to have child support as part of your arrangement, here are some of the potential, future pitfalls that could come as a result of that. If you're not really sure what those pitfalls are, it would be sufficient just to flag it for independent legal advice, right? To say, hey, you've decided you don't want to have child support as part of your agreement. This would be something important to talk to a lawyer about, to have independent legal advice. Now, you might boomerang back to Parker saying, well, I don't want to have independent legal advice. And so then how will you document that on your file so that you always have something beyond just relying on your memory that you can then refer to say, yes, well, we did talk about this. Ultimately, this was the decision that they reached. As a mediator, you can't give them advice, and you can't give them legal advice or any kind of advice for that matter, but you can certainly provide information for them and encouragement, and you can also set your own parameters. So as I mentioned before, if your parameter is going to be, all my clients have to have independent legal advice, the key is letting them know that up front, having that be part of your agreements on the front end so that those expectations have been set. The next thing to reflect upon is whether or not there's anything missing from their agreement. So thinking about what they've decided to do about the property as an example, and I'm not suggesting it's the only thing. I'd like you to engage in this exercise on your own to really be mindful of those different buckets of substantive law: property, the financial piece, and the parenting piece. Is there anything that maybe it seems from that summary that they haven't maybe fleshed out the details that need a little further discussion? So with respect to property, we know that Bonnie and Parker have decided that they're going to share the expenses related to the family home until the family home sells. Well, what if the family home doesn't sell for 5 years? Are they going to continue this nesting arrangement? Do they have a list of what those expenses are so that there's clarity? They might say to you, oh yeah, well, we know what it is. But if they actually sat down and made the list, then it could generate some discussion, because Parker says, well, hold on a second, why am I paying 50% of utilities when I'm only there on the weekends and you're really generating the greatest cost for utilities? Now, Bonnie might say, well, it's not just me, it's also the children. And since we've agreed that there's no child support being paid, then at the very least you can contribute to the utilities. And so just, who knows what Bonnie and Parker will say? That's just an example. So when you go through that list of things that they've agreed to, think about whether there's anything that's missing that would be important to flag and have included in their agreement. Now, just to switch our mindset here for a moment to talk about logistical considerations very, very briefly. So we do offer a workshop on making money mediating, where we talk a little further about how you really identify your business and the why behind why you're a mediator, and how you reflect that in all your marketing as well as your documents that you prepare for your clients and correspondence, etc. So we're not going to dive very deep into this, but I just want to make this note to say, every time you're creating an agenda, every time you are drafting a summary, every time you are sending correspondence, whether it's by email or a letter or it's scribbled on napkin by pigeon carrier, probably don't do that. It's harder to put your branding on a napkin like that. Whatever your correspondence is, you want to be thinking about, how do you reinforce the message that this came from you, because you're going to be building your practice primarily from the referrals that will come as a result of building relationships with your first clients. And you will also engage in other things, whether it's social media or billboards or whatever kinds of marketing activities you participate in, and your branding will be part of all of that. But really, your primary source of ongoing work is always going to be the goodwill that's generated from happy clients. And so having your contact information, whatever your logo is, your branding, on all of those documents will help keep that a possibility alive around, because you'd think that your name would always be memorable, but it's really interesting to us here. Sometimes we'll have people who will talk about having worked with a mediator or a lawyer a number of years back, and they can't even remember where the office was, let alone the name of the person. And so you go and you look at the documents and you see the name, you see the logo, and then you know where to go if you're needing more information. So it's just really important to put your mind to that as you're generating these documents. The difference between an electronic and a wet signature in these times right now, where there's a lot more remote mediation that's happening and virtual, there are ways in which you can still witness signatures, through video. And so an electronic signature that might be part of an Adobe program or a DocuSign program, whatever software you might have that helps facilitate the electronic document. There's a way to have signatures on paperwork that way. Or you could just visually watch somebody sign and then you're still witnessing it. There are some certain documents not likely to fall into the work that you do, but just so you understand the difference, that require what's called a wet signature. It doesn't mean it has to be wet, but it comes probably from back in the day where we wrote in calligraphy and ink was actually literally wet. But I might sign a document and you see me sign it, but I need you to sign that same piece of paper that I signed as well. So rather than you just have your own copy there that you sign, I have to send you the document that I signed so that you are also signing it as well. And it's not done through an electronic means, but we still might be witnessing each other's signature, or I might witness just your signature over a video screen. So you don't have not to get unnecessarily confused by that. Just know that if you're meeting in person and people are signing, whether it's retainers or agreements to mediate, or ultimately memorandums of understanding or separation agreements, or they're meeting with their lawyers to do an interspousal agreement, then they might do it virtually, they might do it electronically, they might do it in person and be a wet signature. And all a signature does is provide some evidence as to who it was who has made that commitment. And that is where the witness comes into play, because if you sign something purporting to be me and somebody else witnessed you sign it, then when I come forward and go, hold on, that's not my signature, the person who witnessed you signing can say, well, no, that was not who I saw sign it. It was that person over there. That's who I remember signing it, which is why it's really important to always get people's ID so you know whose signature matches up with the person. Ethical dilemmas, I think all the way through our program, we've been highlighting where there are occasions that give rise to ethical considerations. The primary ones is, remember that it's super important for you and your clients all to be on the same page around what level of transparency, what your role is as the mediator, that it's not to give legal advice, not to give advice of any sort, in fact, but you're there to guide them through a process, help facilitate their conversation, help them get to a place where they have reached an agreement that they can rely on. And that might be also by involving other professionals, whether those professionals are there in a support capacity, perhaps for counseling purposes, or for other types of information like financial planning, or those lawyers that are there for the independent legal advice. So for clients to understand what your role is, how you're going to be communicating with them, where those written documents go, what audience that they're intended for, what audience they're not to be shared with, and just to have as much I guess written documentation for your file as to what the agreement is on between you and the parties around the communication and those written documents. So it's a written document about written documents, and that written document about written documents can actually be your retainer agreement and or your agreement to mediate that just sets out what those parameters are. you should practice this. Remember to use your effective listening skills to identify what the relevant terms of agreement might be and issues to flag for independent legal advice. If you'd like to go back to Bonnie and Parker's slide and practice, thinking about, well, if this was ultimately their agreement, how can I take that information and what might it look like if I put it in a separation agreement or a memorandum of understanding? How might it look different if I just embed it in a letter that's going to go to the lawyers? Or am I going to do both? Maybe I have a transition letter, but also a draft agreement or memorandum of understanding for the lawyer to consider. And so you're listening if you are participating in a role play so that you can gather that information, try putting it in a summary, and then try creating a transition letter and a memorandum of understanding or some sort of a draft agreement. If you don't get enough just from doing it as a role play, you can also, and you can do it in a different order if you'd like, and go back to the Bonnie and Parker slide and take the information as documented there and put it into a transition letter and or an agreement or memorandum of understanding. And if you would like to upload your assignments onto the Slack channel to get feedback from peers, that's one option. We're also happy to take a look at those documents when you've prepared them to give you some feedback as well. And do this many times, even once you start actually working on files. You're going to be doing it while you're working on your files, of course, but you can always participate in role plays and try different assignments. If you're part of a PODS program, it's a regular engagement in written assignments so that you can keep those skills sharp. You always want to be thinking about plain language. The documents that I've shared with you for Fred and Wilma are not necessarily in plain language. So go into those documents and rip them apart and think to yourself, well, what would be a better way to word this? What is missing that I think should be added? Make the formatting your own. You will probably have some questions and hopefully we'll have some answers for you. And so we encourage you to post your questions in Slack as well as to feel free to call or email anytime. And we would love to engage with you further on this topic as well as all the other things that we like to talk about here at the Academy. Thank you for joining us for this workshop. I look forward to seeing your drafted agreements cross my desk sometime in the very near future.